All right, welcome in. This is the Front Row Podcast. I'm Coach Mark Gottfried, and I have a phenomenal guest today. I'm excited about this. And full disclosure, I have Scott Tompsett, and Scott is an attorney that has represented probably over 100 coaches throughout your career in lawsuits and litigating cases versus the NCAA. Scott was my attorney, and he and I not only work together, but we have a great friendship and relationship. So when you talk about expertise with NCAA cases, when rules are broken and the NCAA comes into different schools, coaches, players, whatever it may be, it's sometimes very complicated for the normal fan that's at the games to watch. And so I'm looking forward to this today. This is going to be a lot of fun. So, Scott, welcome. Welcome to Newport Beach. Welcome to the Front Row Podcast.
Happy to be here. Thanks, Mark.
So let's start, and let's talk real briefly a little bit about how did you, as a trial lawyer, end up in a practice where you kind of zoomed in on the NCAA coaches and all the things you've done here in the last decade or so?
Right. So I went to law school. I didn't go to law school with any intention of being a sports lawyer. I went to law school because I wanted to be a litigator and a trial lawyer. I graduated from law school in 1990, joined a large firm in upstate New York, and my firm did a lot of legal work for Syracuse University. And you've been around about as long as I have, so you remember back then in 1990, early 91, Jim Boeheim and his program came under investigation for Rob Johnson down in New York City and Conrad McRae and some of that stuff. And my firm represented Syracuse University in that case. And while that case was going on, they opened a branch office in Kansas City, Missouri, where the NCAA was located at the time. I was a first-year associate. They asked me to go out to Kansas City, help open the office, which I did. I spent a year out there, got my feet into the NCAA enforcement process, representing institutions at the time, returned to Syracuse and kept doing that work and started building my litigation career. I went back out to Kansas City in 95 full-time, represented institutions for another 4 years. And then I went to a different firm in Kansas City to resume my trial practice. And at that time, I started representing coaches. And over time, I built my practice representing primarily coaches, a lot of basketball coaches, football coaches, some coaches in other sports, also student athletes. And about 10, 11 years ago, I took my sports law practice solo, and that's where I am.
And here we are. So going back, I had coached college basketball. Most of the people that will tune into this know my background. And I had years and years and years, probably 25, 26 years, where really I had no issues, no run-ins, no mishaps where the NCAA was ever involved with me. And then all of a sudden, while I was coaching at NC State in a very complicated, very well-publicized case with the Southern District of New York and Adidas and Nike and everybody, it was a very interesting case. But all of a sudden, the targets were set on our program. So I had to hire an attorney, and I had to figure out, okay, what do I do? I've really never done this. And as I called around to some of my friends in coaching, the name that kept coming up was your name. This is your guy, Mark. This guy knows the ins and outs of the NCAA probably better than anybody, and has an expertise in that can help you kind of navigate through this, because this is uncharted waters many times for coaches. It's your first time. A lot of times you've never been in this situation, and sometimes, like in my situation, because I was no longer employed at NC State, you end up, it's kind of this big giant of the NCAA fighting this one individual or coming after this one person. Different than if you're still employed and working and coaching, where you have the school behind you. So I jumped in there with you, and again, like I mentioned, you and I have had great working relationship, and then we've also become friends. But why? I guess maybe the question is, with coaches, you've been around this so long. If I was just somebody say, Scott, why you? Why you instead of this guy or that guy or that guy? Give me you've kind of told me ahead of time, but give our listeners that kind of answer as to why you, instead of, I'm sure there's a lot of good attorneys out there, but I think you're the best one.
Yeah.
That's my personal opinion.
Well, for better or for worse, I've been doing it now longer than anybody in the country. I've been continuously practicing in the NCAA infractions area and enforcement area since 1991. So coming up on 33 years. And in that area, most of the practitioners, most of the attorneys who work in that area focus either on institutions or student athletes. There's some that do some crossover, but and a lot of them really try to focus on the institutions. I've got a broad spectrum of experience. I've represented dozens of institutions back in the 90s when I was with the firm that I got into this with. So I see it from that perspective. I've represented more coaches than any attorney in the country by a wide margin, both head coaches and assistant coaches. I've represented student athletes, prospective student athletes. I've represented boosters, compliance officers, athletic directors. So I have a wide spectrum of experience that helps me see things from different angles. The other thing that I think I bring to the table, there's a lot of attorneys in the NCAA world, or some of them, who have only practiced in the NCAA world. I've been a trial attorney throughout my career, and this is why that's important. First of all, if you've been in courtrooms and you've litigated cases and tried cases, it helps you build your analytical skills, your advocacy skills, which are important when you're representing a coach in an infractions case. But also, when you're representing a party in an NCAA infractions case, my goal is to, if it's a coach, to guide the party, to guide the coach through the case, bring him out the other end as successfully as possible, hopefully with his job still intact, his career still intact, his reputation intact. That doesn't always happen, and there's reasons for that. But if at the end of the case the coach has lost his job and he can't get hired again, or his reputation has been damaged, he's been defamed, that coach has the option to sue the NCAA, or perhaps sue his institution if they fired him. The success of that lawsuit is going to depend in large part on the record that was built in the NCAA infractions process. And being a trial attorney, I can look ahead 5, 6, 7, 8 steps when I'm representing a coach in the infractions process, and I can build a record for a successful lawsuit if the coach needs to go there at the end. And the perfect example of that, you and I have talked about this, and it's a high-profile case, is the Todd McNair case.
Mm-hmm. Which was, and explain that one to most people, because most people they remember Reggie Bush.
Yeah.
They remember the Heisman, remember USC football. They remember that whole era and Reggie Bush and, the Heisman Trophy, and they took it away. But the Todd McNair case was different. And you represented Todd. And that was a long lawsuit, correct?
It's my longest representation of a client since I've been an attorney. The NCAA started investigating USC, I think it was 2005 or 2006, shortly after Reggie went to the NFL. And they investigated for 3 or 4 years whether Reggie took what the NCAA calls impermissible benefits from agents who wanted to represent him once he went into the NFL. And I got a call from USC in August or September 2009 asking me to represent Todd. The notice of allegations was about to come out, and the allegation against Todd was really very narrow. It was not that Todd arranged or provided the benefits that flowed through to Reggie and his family from these agents. It was that he knew about it, and he had a duty to report that to USC or to the NCAA, and he didn't report it. And I thought I had a very strong defense of Todd. The evidence against him was weak. It wasn't very credible. It wasn't very reliable. It wasn't corroborated in many aspects in a credible way. And we went through, and the NCAA made the finding against Todd. and they crushed USC, by the way, also. We appealed it, lost the appeal, and Todd had lost his job at USC in the meantime. And again, all along the case, I was preparing a record for litigation if we needed to go there. Todd chose to bring a lawsuit against the NCAA. I co-counseled with a tremendous attorney here in Los Angeles, at the time he's out of Santa Monica, Bruce Broylette, and we sued the NCAA for defamation in June of 2011, and the lawsuit went forward. We just settled it almost 3 years ago.
Wow.
10 years. And ultimately won, but it was a long, hard-fought battle. And the thing about that lawsuit, and there's been a lot written about it, it was very high profile, very well covered by the media. In the time since, as I've thought about it, the thing that kind of sticks in my mind is, the courts in that case, and the court decisions are out there, people can read them. The courts came out with very harsh decisions against the NCAA. I mean, using words like malice, that the NCAA acted maliciously, which is a high standard. Mm-hmm. That doesn't mean they were just negligent, they made a mistake. It means they were doing things against Todd that were wrong, and they knew they were wrong at the time, and they still did them. Mm-hmm. And the NCAA defended this lawsuit for 10 years vigorously. And in the face of what I thought, and I think Bruce thought, and many people around the country and journalists who wrote about the case thought was overwhelming evidence. And the NCAA stuck to their guns. To this day, the NCAA has never acknowledged wrongdoing or apologized to Todd McNair. And the thing about that kind of sticks with me, because I'm still doing this, I'm still representing coaches in these cases. If the NCAA at the highest leadership is going to, defend that type of conduct that they did to Todd McNair, what does that mean going forward?
Right.
And I think the Todd McNair case did a lot of damage to the credibility of the NCAA.
Scott, you and I have talked about this many, many times, and I kind of want to hear your thoughts, although I feel like I know what they are, but I want all of our listeners to. And I kind of always go back to there was this kind of a quote that I always really enjoyed from Jerry Tarkanian, the old coach at UNLV, and he was constantly battling the NCAA, and they were coming after him, and then, lawsuits, and it was back and forth. But, he made a comment that said, a lot of times they'll investigate Kentucky and then put Cleveland State on probation. Yeah. And, it was kind of in jest, but as I've gone through 30 plus, almost 35 years in college athletics, it's hard for me not to come to the conclusion that some of that is pretty true. Because, and I want your opinion on this, I want you to tell me how you feel about this. So many times, and here's what sometimes the general fan that follows their teams, they really don't kind of get into the weeds and understand. So many times, if a school has the resources, the financial resources to fight the NCAA, then it's also it's a commitment to fight them. Because a lot of schools may have the money, but they just don't want to fight them. But if a school has the resources, if they have the resolve to say, we're going to fight them. Not always, but typically the school kind of comes out okay. And a lot of times that's the schools that are the bigger, more prominent schools, the people at the top of the food chain. Then you have all these other Division I and Division II and Division III, but primarily Division I schools that are, kind of a little bit farther down the food chain. They don't have the resources. They don't have the money, nor do they really want to fight it. They don't know that there's a lot of gain for them to fight. And so they just kind of fall in line and take whatever penalty the NCAA is going to give them. But there's some truth to that, in that if you're at a school that really doesn't want to fight or really doesn't have the money, you're kind of up the creek a little bit, as opposed to being at somewhere that says, okay, we're going to pony up, we're going to lawyer up, we're going to go after this thing, and we're going to put people like yourself who have the expertise to challenge the NCAA. And so sometimes I think what he said was accurate. What say you to that comment?
Oh, I think I mostly agree with what you just said. I wouldn't say that the NCAA, will just target the smaller schools. Recently they went after the University of Kansas. I represented our friend Bill Self. They went after Arizona. They went after Louisville, NC State.
But let me interrupt you real quick. They went after those, and I'm not saying they don't ever go after those, but they had no choice to because of the public. It was out there because of the Southern District of New York case and all of that. It was everywhere in the media, so you almost couldn't. Correct?
I don't have a problem with the investigations of those schools, and specifically the cases I was involved in. But I could talk a long time about the overreach in the allegations that were brought.
Right.
Okay. But in terms of the resources and the ability to fight and the will to fight, you're 100% right. I mean, the smaller schools, I don't mean this in a derogatory way, but the administrations tend to be a little bit less sophisticated than the larger schools. They're less invested in their athletic programs, okay? They don't have the money. And I represent coaches across the spectrum. I represented you, of course, and I represent 3 Hall of Fame coaches, Jim Calhoun, Bill Self, and Rick Pitino. And I've represented coaches in D2 schools, And it's a different strategy. It's a different fight when you're representing, a coach without the means, without the resources. And the goal is, let's just try to get through this. Let's, maybe we can go along to get along, because I don't agree with what they're doing to me or my program, but I can't fight this for 3 or 4 years.
Right.
So, yeah, I agree with that.
How about some of you've obviously had so many cases, and, those that are close to me know that I don't have a great allegiance towards the NCAA. I'm not a fan, and I don't trust them. That's where I get to, not the fact that we as coaches don't make mistakes. We make them. You make a mistake. I mean, that happens. We're human beings, and it's a competitive, highly, highly competitive field that we're in. I mean, and mistakes happen. They happen all the time. And I've always felt, though, that rather than the NCAA being somewhat of a partner to say, yeah, I get that, and we're going to work through this, I've never felt comfortable in dealing with them. And I'm going to give you an example. I was coaching at Alabama, and at the time, Mal Moore, the athletic director, one of my favorite people on the planet, he brought in this young lady from the NCAA, and she was talking about different things. And so we got all the head coaches sitting in a room. And she brought up a case and said that at the time, I think it was involved with football, there was a school that had got a commitment from a high school senior. He's going to commit. And then that high school kid began to then encourage his teammate to come along with him, to go to that same college. And she tried to convince us that teammate all of a sudden, or the guy that had committed first, that he was now a booster of the program. Yeah. He's now a booster because he committed, and he's going to try to encourage his best buddy, who's his same age. They're both 17 years old. Hey, come with me. We're both going to play at University of wherever it was. And I stood up and said, time out now. Hold on. Stop. That's ludicrous. That's it. That's ludicrous. He's 17 years old. The guy wants his buddy to come play with him. And she tried to convince us that that student athlete was now a booster. And I was like, okay, I don't really know where to go from there. Because it was almost they could handpick anything they wanted to and turn it any way they wanted to that would work against a school if they wanted it to. That's how I felt. I don't know how you feel, but that's how I felt.
I don't know if I can put it better than the way you just put it in your last sentence. The rules, such as they are oftentimes so kind of wishy-washy and so loose and subject to interpretation that it leaves the NCAA, whether it's the enforcement staff doing the investigation and bringing the charges, or the Committee on Infractions, which acts as the tribunal, to drive the case, if they choose, to the worst outcome. And I often see that. That's my perception. that, we have a set of facts here. We all agree what the facts are, okay? We understand that this rule probably applies. Sometimes they try to shoehorn the facts into a rule that I think doesn't apply at all.
Right.
Okay, because they're going to get a violation. But driving it toward the worst outcome, and I should say something here because we're bagging on the NCAA, and I've done a lot of cases. I've done a lot of cases with the NCAA that we get through the case, we do the investigation, and at the end of it, my client, the institution, the people involved, hey, you know what? We're not thrilled about the outcome, but we're okay. It was an okay process. It's not that every case has significant flaws or problems, but in my opinion, more do than should.
Mm-hmm.
And the other thing I'll say about this, and I've said this for a long time to anybody who will listen. Coaches, this goes back to what we're talking about so much at stake. Coaches lose jobs, they lose careers, they lose reputations in an infractions process. And I've said this for a long time. If that's a possible consequence, okay, and sometimes that needs to be the consequence. Sometimes a coach does something that's so bad, you know what, you probably should, not be working around young men or young women.
Right.
Okay, that's the rare case in my opinion.
Right.
Okay, but my point is this, 2 points. One, if that's possible consequence, you better really give a fair process, okay, to the coach, to the school. If that's, where you're going to end up, you better make sure that coach had every possibility, every right to defend himself, to tell his side of the story, to go out and develop evidence himself, that sort of thing, okay? That doesn't always happen. But the other thing that I've said, I'm a lawyer, right? Lawyers are subject to their own ethical rules. It's called the rules of professional conduct. Every state has rules of professional conduct that every licensed lawyer has to abide by. And lawyers screw up too. Lawyers, there's unethical lawyers. Lawyers go out and sometimes violate those rules. It's mostly the rare case when a lawyer ends up losing his license to practice law. It happens, but you got to really screw up.
Right.
Okay. In the NCAA world, and I've seen it progress over the time I've been doing this. More and more, I see coaches, lose their jobs, and once you get tarred with that scarlet letter,
mm-hmm.
By the NCAA, you're a cheater.
Yeah.
Try to get another job.
I know.
So, is it really reasonable
mm-hmm.
that we're holding coaches to a higher standard than what lawyers would be held to?
Right.
It doesn't make sense to me.
There was a time, Scott, when and you would probably remember the time frame better than me, but I felt like the NCAA was beginning to get frustrated, and they came up with a new term called failure to monitor, which you and I are familiar with in regard to my case at NC State. And it was almost like, in my view, and I'm real curious for you to share your opinion on this, the general consensus was, coaches, assistant coaches were doing things, and then the coaches would kind of hide back and say, hey, I didn't know anything about it, therefore I'm in the clear, and it's all on my assistant coach.
Yeah.
So this term came to be where now we have this thing called failure to monitor, head coach control.
Head coach control.
And amongst that, now you take a coach, and the coaches who are coaching are supposed to be aware of everything that's going on by their assistant coaches or everything in their program.
Yeah.
Which, in my view, having been a head coach for over 20 years, it's just impossible. Yes, should you create an atmosphere of compliance? We hear that term all the time. Absolutely you should. And you should try as a head coach to do that all the time. But sometimes things happen, and sometimes the coach isn't aware. They're just not. And it was almost like we're just going to throw this blanket over top of everything else. So if all else fails and all else fails, we can get you on that one. We'll pin that one on you because you should have been able to monitor that better. Mm-hmm. Now, here I am as a head coach. I have assistant coaches who are grown men. They're grown-ups. They're adults. they're trying to win too, and they're trying to do their jobs, and they're human beings. But I was so opposed to that whole period of we could just blanket this thing on top that says you failed to monitor. I just never felt like that was fair. I didn't think it was just. I didn't think it was reasonable. Sure, at times. I get all that, but it was a little too much for me as a college coach to put that on a head coach. In other words, anything that happens in your program, you should have known about it. Mm-hmm. Well, there's corporations in America that I don't know. Sometimes people don't know what their people are doing. Mm-hmm. So what's your kind of take on that one for me, that whole failure to monitor thing? Because to me, I'm not a big fan of it.
Well, the background is, just briefly, you're talking about the head coach control rule. It's in bylaw 11 of the manual, and it was first implemented in 2004. The NCAA, the membership apparently, because it was passed with approval of the membership, they were tired of coaches coming in and saying, I didn't know about this, you can't hold me responsible. So they passed this bylaw, and there have been different iterations of the head coach control rule. The first iteration was the head coach is presumed knowledgeable of what his staff is doing. And if somebody on his staff who reports to him commits a violation, the head coach is presumed knowledgeable. Now, it's what they call in the law a rebuttable presumption. So you can come in and you can argue, look, maybe somebody on my staff did something. I did everything I reasonably could to avoid the violation by promoting an atmosphere of compliance and monitoring my program. And I represented, I'm sure, more head coaches under that rule than anybody in the country. And I successfully defended some of those cases. They changed the rule in 2012. Too many coaches were getting off.
They didn't like that.
So they upped the ante. They said, forget about this presumed knowledgeable, because coaches are coming in and they're saying, hey, I didn't know about this. You can't prove I knew about it. And then the coach, So they said, we're not talking about your knowledge anymore. From now on, we're going to say you're presumed responsible. Whether you knew about it or not, you're presumed responsible. You can still rebut the presumption. And I continue to represent head coaches, and I won some of those cases. Now you can just forget it. And by the way, even under the old version, it almost used to be like, it didn't matter. I mean, I'd bring a head coach in some instances where I truly thought, man, I got a great record. This coach did everything he reasonably could be expected to do under the circumstances, and there was still some violation, and they would tag him anyway. And they said, yeah, you know what, we're not going to have that debate anymore. So last year they changed the rule, and now there's no rebuttable presumption. If you're a head coach and someone under you who reports to you commits a violation, it's strict liability. It doesn't matter what the facts and circumstances are of the violation. The assistant coach could have gone out and committed a violation completely for his own benefit, could have done everything that he could think of to hide it from the coach. The coach could have promoted an atmosphere of compliance, could have monitored. As I understand under the new rule, the head coach is going to get tagged with a violation, and all we're going to talk about is what the penalty should be.
Which is frustrating, as a former head coach for a long time. Yeah. And it just seems to me at times it's just like hell or high water, I'm going to get you. I'm going to try my best, to get you. As opposed to, like we said earlier, looking at the facts, just laying them out there and let's see where it goes. It's almost like at the beginning, I'm going to make my mind up that this person should be or shouldn't be. And they just kind of end up at the conclusion they want to. I don't know that that's always true.
It's not always true. I certainly would agree. It's not always true, but I contrast my my litigation practice with my NCAA practice. Okay, and I've been in courtrooms all around the country. I can't remember ever walking out of a courtroom and thinking to myself, "Man, we just got jobbed." That case was directed to an outcome from the start.
Yep.
I may not have liked the judge's decision. I may not have agreed with it. I may have thought he should have done things differently. But I have had cases in the NCAA world Not a ton, but you shouldn't have any, is the point, right?
Right.
I mean, every case, because what we talked about, they're so important and there's so much on the line. I have had cases in the NCAA world where I represented a coach or another individual in a case, and at the end of the case, despite, my best efforts, I just felt, wow, they knew where they wanted to take this case, and that's where they took it.
And I feel that was a little bit to do with in my own. And I've always told all my friends, I've said it on these podcasts, Scott, and I'll say it, I'll stand on a mountaintop and say it. Every mistake I've ever made, I own them. I own them. I own the mistakes, and whether it was poor judgment or just trying to get a competitive edge, we make mistakes. It's part of it. But that's how I felt in ours, in my situation, where, their minds were made up. And regardless of what you and I presented, it was just kind of bumping into a brick wall. It just didn't seem like there was a whole lot of understanding. And then I think a lot of people don't realize too, Scott, and we've talked about the committee they put together a few years ago in light of the whole the nationwide, the Southern District of New York and the Adidas case and all that. But when you're talking about the infractions, the committee on infractions, a lot of times, again, you're talking about what they want to perceive to be you're going up against or going to present your case to a jury of your peers, which might be the head of the English department at University of Iowa,
right,
or the the dean of the chemistry school at Idaho State. Yeah. And all of a sudden, this group of people that really aren't involved in athletics are now they're weighing in on your future, truthfully. Yeah. And I know for me, I didn't like that. Yeah. I wanted to stand in front of a group of my real peers. Yeah. Put 10 athletic directors up there. Yeah. I'm fine with that one. Yeah. But when you start hodgepodging people from all kind of different walks of life, even though they work on a campus or they've worked on one for 30 years, I wasn't real comfortable with that one. Yeah. I wasn't a fan.
Yeah. Well, that's what they call their peer review process. The NCAA is a voluntary association, legally speaking. What does that mean? It means that legally speaking, in the way that courts treat them, they're same as your local homeowners association. They get to create their own bylaws, they get to create their own enforcement mechanism and their own penalties, and this is what they came up with. And they have had this peer review process for years, and you're right, there are professors of English and chemistry and so on. There also are athletic people. There's some ADs, they usually have a coach. In the IARP process that you talked about, right, that they developed, they adopted in response to the Rice Commission report in early 2018 because of the Southern District cases. And they came up with this independent accountability resolution process that, according to the material they put out, was intended to process the high-stakes cases, complex cases. And most of those Southern District cases went in there. We could do a whole piece on this, but I can tell you, with the outside, and they brought in two groups. They brought in the complex case unit to investigate the cases in place of the enforcement staff, and then they brought in the independent review panel to act as the tribunal in place of the committee on infractions. I can tell you from personal involvement and speaking with attorneys who were involved in some of those other cases, I think that clear consensus was that the hearings in those cases, which everyone needs to understand, that's like the trial. The committee on infractions is the peer review process. In this outside track, we had the independent review panel. I think the clear consensus was that the hearings were conducted much more thoroughly, much more in a professional legal sense, more objectively, and I think the decisions that came out, some people just want coaches to get hammered. It doesn't matter, but people were upset at that. But if you really carefully read the decisions that they put out, they're well reasoned, they're supported by facts. The NCAA, in their wisdom, abolished that whole process. Now we're back in front of the Committee on Infractions.
Yeah. What is your take, Scott? Obviously, in the last couple of 2 or 3 years here, landscapes have drastically changed with the NIL.
Yeah.
And then, a lot of people, they talk about the fact that the transfer portal, the creation of the portal itself, and then the bylaws that say a student athlete doesn't have to sit out and they can transfer without sitting out, which I did back in 1982 and 83. I sat out a year as a redshirt when I transferred, and I coached many guys that did that as well. But the opportunity for student athletes to be compensated using their name, their image, their likeness, if you put their name on the back of a jersey, or if they're in a video game, or if they want to go sign autographs or whatever, they now can get paid, get compensated.
Right.
Kind of that whole thing happening at one time, and kind of your take on that. The NIL, the good, bad, and the ugly, the portal, kind of all combined.
Yeah. So, well, I'll preface my comments by saying I know you had Jay Billis on there, our mutual friend Jay, and I watched that, and Jay speaks as insightfully about these, especially the NIL stuff, as I think anybody in the country. And he's been speaking about it for a long time. So, my thoughts, one, on the transfer portal, and I know coaches don't like it. I mean, I understand that, if because guys can transfer freely. I represented many players under the old system trying to get waivers. The old rationale, and you know what the rationale for making kids sit out, the rationale, and it only applied to certain sports.
Right.
It wasn't across the board.
Right.
But it was that these student athletes in these particular sports, if they transfer, they need to sit out what they call an academic year in residence to get acclimated to the new school. Well, if it's okay for football and basketball and baseball, what about the track and how come they don't have to sit out?
Right.
It was an NCAA rule, with no rational justification.
Right.
So I think getting rid of that, I think it was the fair thing to do. Some coaches, Bill Self has adjusted to it tremendously. He lost a lot of guys last year and has built his roster back up. On the NIL, that's the thing, and I think Jay may have. I think Jay mentioned this when you talked to him. That was something, Mark, and you know this. I mean, it's not something that just popped up recently. It was something that was building for a long period of time. I don't know, 25, 30 years. Going all the way back to the 90s or the early 2000s and the EA Sports thing. And it was just fascinating to watch that an organization like the NCAA, right, an organization that represents some of the best colleges and universities in the world, right, and the resources that they have, right, and there was very little effort, from what I saw and others saw, by the NCAA to recognize this and to try to get out ahead of it, or at least to try to manage it and prepare for where it was going. And that happened over years and years, and over time, and and some of their rules about what student athletes could and could not get. I mean, you're just talking about money for name on the back of the jersey, or selling an autograph, right? Which I represented Johnny Manziel when he was at A&M, and he sat out half a game.
Right.
That's kind of un-American. Okay, first of all. And people started to become aware of this, and it seemed like a consensus built against it. And they had other, kind of in the industry, one of the stories that goes around, Oklahoma, I think it's the University of Oklahoma, one of the former Big 8 or Big 12 programs, reported a violation to the NCAA that at their end of season banquet, some of the linemen went up and got an extra helping of pasta. And the NCAA,
get them, put them in jail.
And the NCAA, they used to regulate, because you could pay you could give your kids training table during season, right? Mm-hmm. But they would regulate that. Well, during this period of time, they can have a snack, and then they can have a meal. Well, a snack is a bagel, but if you put cream cheese on it, it's a meal. Mm-hmm. But the NCAA, they had so much opportunity to get out ahead of this. They didn't. They got dragged kicking and screaming into the 21st century by lawyers and courts. And from my perspective, where they are now, they don't have anybody to blame but themselves.
Right.
Going forward, my personal thought is that the NCAA for years, when they were clinging to their draconian, archaic amateurism principles, and they would argue, as I understood their argument was, it's better that the players don't get paid.
Right. No question. No question. Yes.
And they would argue that their model, that the collegiate model would collapse, and players, fans would stop coming to games if players were getting paid. Well, that's not happening, is it?
None of it.
The Final Fours sold out last year. It's going to be sold out this year. People are going to college football games. Players are getting paid. My sense is that, and this is something Jay Billis had said for years. I mean, Jay was way ahead of this. This is going to, I think it's going to work its way. The kind of things in the system now that aren't perfect over the next few years, I think are going to work their way out. Players are going to get paid. There may be a salary cap. Is it pay for play? Yeah, sure, it is. So what? Those are my thoughts.
And I think what's going to happen too, Scott, is right now the coaches I talk to all over the country, and I've also gotten to know a number of people that actually are running what has become now these collectives, which is nonprofit groups that are raising money, and then they're using it to pay athletes at a certain school. They can't officially be a part of the athletic department, but they're kind of sitting over there, and they've raised the money, and we're going to get the 5 linemen to come and sign autographs. We pay them all $100,000, and that's kind of where we are right now. And I've said this many times. My biggest gripe with it, Scott, is that, like you said, this was coming for a long time. This train was coming down the tracks.
Yeah.
And as the NCAA are signing billion-dollar contracts, and a lot of people don't even realize the NCAA, they own March Madness. They own the 3-week tournament.
Right.
That money is for a 3-week tournament, basically. You're talking about all the sites, all the venues, all the parking, all the concessions, all the television revenue, all the stuff, and they're raking in all this money, which they have for years and years and years and years, and you and I have been there. The NCAA headquarters is like Taj Mahal now. I mean, it's marble, like, you walk it into the Taj Mahal. Yet they weren't sharing any of that money, for the most part, with the student athletes.
Right.
And so they sat back and, Ed O'Bannon, the lawsuit, and I coached Ed, and it goes all the way to the Supreme Court, and they basically kind of at the end just have to throw their hands up and say, okay, here we are. We've got to deal with this. So they had opportunities. They just never did. It was kind of a pompous, very arrogant approach, like, we're not going to really deal with this.
Yeah.
But we're going to take all the money. The problem I have, my biggest problem with all of it is they really still aren't sharing all that money. And so what's happening, for the schools to be competitive, and you're coaching somewhere, if I'm the coach at this particular university, and I know them well now, who has and who has not, the haves and have-nots is who has the money. If you're at a school that really hasn't raised a ton of money that goes into this collective, you're in for a world of hurt now as a coach, because you can't compete. If I offer your son $50,000 to come and this school offers him $700,000 to come, well, they're not coming to play for me. They're going to go play and make $700,000. And so the system is just not, they've, in my view, there has to be a way to figure this out and figure out how to make it somewhat equitable. Even pro sports, it's somewhat equitable.
Yeah.
Everybody has a contract. The whole world knows how much the contract is. If you sign a 3-year, $12 million contract in the NBA, okay, the whole world knows it. Everybody in the locker room knows it.
Yeah.
With NIL, nobody really knows. Kids are talking about it in the locker room. Oh, I can't believe you got what? I should be getting more than you.
Yeah.
It's just there's a lot of chaos, in my view.
Well, let me ask
with all
you.
of that.
Let me ask you, as a coach, because I've thought about this. I'm a lawyer, but I don't coach players. I wasn't a very good basketball player. But you're right. The schools with the big collectives, they certainly have an advantage in recruiting. There's no question about that, okay, in recruiting and getting players who they perceive are the best, okay? But these are young men. They're just out of high school, okay? In basketball, you only put 5 guys on the court at a time, roster of 13 kids, right? Okay? There's a lot of good players to go around. And it seems to me, there in the last year, 2, 3 years, there's quite a bit of parity, isn't there? You see some of the mid-major schools or the smaller schools, doing well. It doesn't seem yet, maybe it'll progress to this as you're concerned, that, just these schools with the big collectives are just knocking everybody off every day of the week. I mean, last night, my friend Greg McDermott boat raced UConn by 20 points. I don't know what their respective collectives are. But what do you think about the parity? I mean, do you think that the collectives...
I think there's truth in that. I do. I do. I think that it's an interesting... that'd be a great study to do, to find out. But I think you're onto something there, because it does create parity. Here's another interesting thing, and I was just at the University of Alabama and honored one of the teams that I coached there, and so I've got to know a lot of the people that are there, more prominent boosters at the University of Alabama. And here's another part of it that a lot of people don't talk about. The general fund at the school is being affected because, in other words, let's say that I am somebody that has annually donated to my general fund, have nothing to do with athletics. And I need to put my money, I'm going to donate some money. Well, now I'm feeling pressure to put that money in a collective. So the athletic director, when he needs to have more money to build facilities, he's competing for the same dollar that's going to potentially go from a booster into a collective. The general fund on campus, they're competing for that same dollar. Now, some places have a lot more money than others, and they can survive it. Some, the state of Alabama, I don't know how many people are in that state, 3 million people maybe in the whole state. There's 40 million people in California. But there's starting to be pressure on everybody because the pressure to fund this, to donate money into this collective that potentially can help us get the best quarterback or linebacker or whatever it may be is so great. Now, I never had to donate to that before. I could donate into Alabama's Tide Pride. And now they may use that money for facilities. Or now I could donate over here to the general fund of the university, and they may build new dormitories. But now I'm taking my $1 million, and I'm going to put it in that collective.
So you're hearing that the general funds are suffering.
Yeah, I've talked to some boosters that are saying, I'm getting pressured. Where am I going to put my money? And which goes back to my original point, Scott, that frustrated me was, right now, there are marquee players that can command a true television commercial or endorsement. Bryce Young at Alabama a couple years ago, quarterback at Alabama, he's doing Dr. Pepper commercials. We get that. Johnny Manziel, who you represented, Johnny Football. If in that time period, if State Farm wanted to have him in commercials, he's probably we get it. We get it. He should have been able to make some money off that. But at the same time, it's not just those guys. It's everybody, that's wanting money. I lost my train of thought. But the schools, there's so much pressure to put money into a collective. The NCAA is still, in my view, holding on to all their money.
Not sharing.
The pressure is on the booster right now. Because if I'm the coach, if I'm a football coach at a Power 5 school, and you can read about it every day. We got to come up with 10, 12, 14, 16, 17 million dollars for our roster. And so really that's kind of the pressure's falling onto the booster. And the NCAA, they're keeping all their money to themselves.
Well, there's the NIL decision, but there's also the Alston decision, right? And I wasn't involved in the case. I'm not involved in those cases going up to the Supreme Court. But the Alston decision increased money from the school's budget to give to players. $6,000, I think, somewhere in that in the academic year. It's not a ton, but it's some. But your point that the NCAA is still holding on to all the money, and it's up to the individual players to go out, and raise money. I think that's accurate.
Interesting. There's so many parts of the NIL. It just is the whole thing to me right now is interesting to see which way it's all going to kind of unfold. But it's a topic for everybody, and coaches that are at schools that their schools haven't been able to really put a ton of money into their collectives. They're hurting. Yeah. They're hurting a little bit, and I just don't know until they figure out how to really manage all this in a proper way. The game will survive. The game's always going to survive. It's going to be good. College basketball, college football, baseball, all your sports. But it'll be interesting to me to see which way this goes.
Well, there's been talk of an elite division too. Mm-hmm. Creating a separate division of the really elite schools that do have the capacity and the funds to just compete amongst themselves. And the Big Ten, I just read the Big Ten recently formed some type of partnership with the SEC to focus on issues, and that may be something that you see come out of that.
Scott, what's one or two, maybe, or a quick thought off the top of your head if you go back all the years? Just an interesting case. I mean, you've had a million of them because you've had so many and different. You've covered the spectrum of just about everything out there that's happened. But I'm sure there's got to be something out there where you just said this one right here was really interesting for me. Is there one maybe or two that kind of stand out?
Yeah, well, the Todd McNair case, of course, but that started off just as a traditional infractions case, and it became interesting because we ended up in court in a high-profile defamation lawsuit against the NCAA. But the case that, the strangest or most bizarre case that I've ever had as a lawyer, and I probably ever will have, was representing Josh Pastner in the extortion case that was fairly high profile for several years, where there was a man and a woman who previously were his friends and kind of fans of his program at Memphis and then at Georgia Tech, and then they turned on him, and they initially accused him of NCAA violations, trying to extort money from him. And a story about how I got that case. That started in the fall of 2017, and just a few months earlier that same year, I partnered with another attorney who was a former federal prosecutor, and we came up with a strategy, and we shut down the blackmail like fast and effectively. And I remember thinking at the end of that case, I'll never have another case like this again. And then several months later, Josh calls me one Saturday afternoon, and he had been referred to me, and started telling me, "Hey, look, I got these people, and they were my friends, and they're threatening me, and they're making these crazy accusations. I committed NCAA rules violations. They want me to pay money." And I remember thinking to myself, "This is too good to be true," because I had just finished another case. And I thought, well, I got the blueprint for this case, and I started talking to Josh. He said, no, you don't understand. I didn't do anything wrong. He goes, if they know about violations of my program, I want them to go to the NCAA. I want them to report it. Okay, I run a clean program. And I said, well, okay, I'll represent you if the NCAA comes. And they came and investigated. The case went on for several years, but they initially charged Josh with violating NCAA rules. The NCAA came in, started a big investigation, and it's serious because you never know if they're going to end up where they should end up. Georgia Tech kept Josh on. They weren't firing him. And then the extortionists changed their strategy, and they started accusing Josh of sexual assault. And this was in late 2017, if you remember what was going on. It was right at the height of the Me Too movement, Harvey Weinstein and all this. Mm-hmm. And then it got really serious. Now they're accusing Josh of sexual assault. And I ended up representing Josh through an NCAA investigation where we got him completely cleared. I represented him through a Title IX investigation that exonerated him. I partnered with an attorney in Phoenix, Arizona, who's now become a great friend and a fishing buddy, trial attorney Scott Palumbo, and we sued these people for defamation. They were accusing Josh of sexual assault, and we didn't think they were going to back down, and we sued them. We took them into court. And we used that defamation suit to get evidence that their allegations were not just false, but maliciously concocted. They had a witness that they had bribed to give a statement against Josh, a security guard, who said that he had witnessed Josh sexually assault the woman in a basketball arena before a Georgia Tech game. I found the witness, I flipped him. He came in and testified under oath that it was all a lie.
Wow.
And they had bribed him. And then we took the evidence from the defamation case that the allegations were false and malicious. We presented it to law enforcement, and they used our evidence and indicted the couple in federal court in Atlanta. And both the man and the woman are now sitting in federal prison.
Wow. How about that?
Yeah. And
job well done.
yeah, and it was just it was a fascinating case because it was both NCAA, it was civil defamation, and then the criminal aspect, and it was high stakes, of course. I even got sued as part of that case. The other side sued myself and my co-counsel for abuse of process, and we had to hire our own attorney and got the complaint dismissed and sanctions against the attorney who sued us.
Amazing. Well, we could talk for hours, but I just want to tell you thank you for making the effort. And, one, I've enjoyed our friendship, but I, obviously have great respect for you because of how you've helped me over the years. But I have told many of my colleagues that are coaching, sometimes you put your foot in a bear trap. That's part of the game. I mean, we're human beings and we do that. But if in fact that happens, I always tell them you're the guy.
I appreciate that.
You are the guy. So your knowledge and how you care about it too. So anyway, I just want to say thank you for that. But thank you for coming on. This has been a lot of fun, and I hope that people have, begin to understand a little bit more about how complex sometimes all of these things are.
Yeah. Well, thank you. I appreciate being here, Mark.
Okay. Thank you, Scott.
Thanks.